Welcome to Q&A practice. We'll start with defense attorney. Ready? Here we go. Your Honor, the facts that I assume are going to come out is that the police officers talked to my client and asked him where he was at the time in question, and my client stated that it's Sunday, which means he usually goes down the hill and he usually goes to swap meets or flea markets or things like that, and buys things that he can sell, things like that. Then he goes over to the casino and he's on the camera at the casino. The part that I want to bring up is that he explained to the best of his ability where he was that day, and a police officer, I can't remember which one it was, goes to two of the swap meets that my client had mentioned, and he looks at video of a couple of places in the swap meet, and then he writes a report that says, I looked at all of the security camera footage and I did not see the defendant. And my motion is that if that's what he says, that's fine, but I believe that the district attorney should make sure his witness does not say he wasn't there, that he says I did not see him on the tapes that I looked at. Okay, I'll make an order in limine that you tell that witness not to mention or not use the words that he wasn't there, okay, that he tried to corroborate the statement and that he wasn't able to find in the surveillance, all of that stuff you're free to go into, but not that he wasn't there. Sure, what else? I believe that Ms. Landers is going to be a witness in this case. She is a civilian witness, so she hasn't done this before. There is a couple of areas that I believe are irrelevant as far as her statement would be. One is in one of her statements to the police officer, she mentioned that when she was a child, my client used corporal punishment. I do not believe that is relevant, and I would ask that she not mention anything about that. Number two, just a minute, one at a time. Mr. West, I wasn't planning to bring that out. Okay, then don't, and tell her don't bring it up. These are just as critical as what you planned. You're responsible for her. Tell her not to bring it up. Tell her nothing that I say to you should elicit that opinion. If you think I'm asking for anything about the corporal punishment that she received, the judge has ordered that you still will not do it. You'll be in violation of my order if she does that. Tell her that. And the second thing was there was discussions that were had after this incident occurred on the disposal of the body. I know that she was very upset about the plans that were being made. Again, I believe that is irrelevant. I would ask her not to testify to those types of issues. What he's referring to is the defendant told Ms. Landers, oh, just let the state dispose of the body. I would think that is relevant, and I did want to bring that out because it shows the defendant doesn't care about the victim. He doesn't care about arranging a funeral for her. He just says, basically, I don't care what happens. I think that is relevant, and I would like to bring that up. I think it's relevant to submit it. Okay, anything else? No, sir, that was it. Again, only relevant for the purpose of talking about Mr. Blake's relationship with his now deceased spouse, because I don't know if I clarified it completely. I'm going to say this now. I think I gave a tentative ruling. Mr. West, you are going to tell any witness that is going to testify that they are not going to bring up anything about any physical abuse by Mr. Blake against Ms. Blake. You're going to tell any witness that testifies that they are not going to bring up anything that suggests that Ms. Blake was afraid of Mr. Blake. The basis of my ruling is that I believe it's perfectly fair game to go into their relationship, especially in light of the fact that he apparently made statements or allegedly made statements to the policeman involved that this was a pure paper divorce for financial reasons and that we were still in love with each other. So the fact that that can be contradicted fully, I think whether, I don't know. I mean, it's fully contradicted, but it is fully addressed by other facts you intend to bring out, that you are allowed to bring out statements to other people about her existing state of mind, things that contradict the fact they are a lovey-dovey couple just looking for medical care, okay? So this ruling is subject to change at any time that the court believes that someone is using this as a sword rather than a shield. And once you have a different state of facts that you can address to the court, Mr. West, I'm willing to entertain further discussion on the subject. Anything else either side. One last thing I forgot, when Ms. Landers was here at lunch, she brought with her the victim's Medicare card and a food stamps card, which she gave to Detective Davis. We want those to be marked as exhibits, so we will be doing that, okay? She stated she found those in the victim's home. Strike that, in the victim's car, inside a bag. Okay, anything else? No, sir. Take a break. Good afternoon, ladies and gentlemen. We are back on the record in the case of the people of the state of California versus Stephen Blake. Mr. Blake is present with his attorney, David Franks. Mr. West is here for the people. Who is that next to you? Your Honor, this is Detective Scott Davis. He's my investigating officer. He's going to be sitting with you during the course of the trial. Yes, Your Honor, this is the time where you are going to hear an opening statement from at least Mr. West, I'm certain. I will remind you that what the attorneys say is not evidence. They are going to show you an outline of what they anticipate is going to be shown during the course of this trial. Mr. West, you get to go first. You may proceed. Thank you, Your Honor. Mr. West, thank you. Mr. Franks, will you make an opening statement at this time, or would you reserve? Yes, sir, I'd like to make one now. Please proceed. Thank you. Thank you, ladies and gentlemen. That is all you are going to hear from the attorneys now until the trial is concluded, and then you'll hear their arguments at the end of the evidence. Mr. West, call your first witness. Thank you, Your Honor. The people call Deborah Landers. Right, let's see what we have here. Some more Q&A practice. And we will start with the court. Ready? Here we go. Do you want to wait? Are we going to argue that issue right now? Do you want to wait? I don't know if you want to do the rest of the motions first and argue them all at once. No, we will take our 15-minute recess. You can make your phone call. I expect to have 59 jurors available at 1:30. Be back in 15 minutes. We are back on the record. In the case of the people of the state of California versus Sam Perez, present with his attorney, Mr. Donald Allen. David Franks is here for the people. We have just completed, I believe, all of the evidentiary motions that we need to discuss. Is that correct? Yes. Yes, sir. Okay, now with that in mind, I'm going to sort of go now off the order and go to page trial brief 6. I got it. I'm going to have you go to page 6, Roman numeral 5, motions in limine. 1 is already done. Mr. Allen, as these are his motions, I'm going to ask you any objection to number 2. Yes, although I would like that to apply to both sides. In other words, you don't object to it as long as it's mutual and reciprocal. Yes, sir, that's the order. I'll just use the word mutual. It's shorter than reciprocal. And I know how to spell mutual. I already said that 3 is granted, but I did it in the reverse order of refusing to exclude it rather than granting the admission. 4, I'm going to grant that. I'm going to object. All right, tell me why. Well, the way it's written, this is pretty much just an open check. They want you to sign it, but they didn't put in the amount. Well, let me put it this way. The way that I read it is victim statements. And while there's mention in both the daughter and this person, Ann Ryan, if there's statements, for some reason Mr. Franks uses the questionable exception to the hearsay rule 1250, and I'll say, why bother with that? It's an admission by a party. No, it's not an admission by a party. No. Oh, it's victim statements you want to get in. Yes, so victim's statements to Sarah's of her then existing state of mind, not of Sarah's state of mind, but of the victim's state of mind. What about that, Mr. Allen? Here is the problem, Your Honor. We have a number of statements that have been provided. I have no idea which ones of those he intends to use. I think it would be much better if we say these are the statements we intend to use and talk about those specifically. But generally, I don't believe that a time. For example, If they have a statement that was made in 2009, I don't believe that would be relevant, or 2012, but perhaps if they were close in time to the date of the occurrence, there may be some relevancy. Again, I would object to, the blanket request without knowing what it is they are trying to get in and what state of mind, and if the particular statement that they are, "You said enough, I'm with him, Mr. Franks." Yes, I would intend to be introducing only those statements made in 2013, which the murder occurred on June 9th of 2013. The divorce was filed in, I believe, March or so of 2013. I would only be eliciting those statements where it was understood that there was a divorce pending and it was going to happen soon. May I respond? Just one second. There's a couple of things I'm wondering. First of all, statements to her daughter, Sarah Richards, and her friend, Ann Ryan, whose friend is Ann, the victim's friend. Okay, pesky pronouns. We have the date of death, or at least we have the reported discovery of the body was June the 9th, right? Yes, June 9th, late in the evening. Okay, now when is your best estimate that you can establish this time of the statements that you wish to admit, Mr. Franks? Well, we will take it with Ann Ryan first, according to a report provided as page 495 of Discovery, that the victim told Ms. Ryan, quote, several months ago, which would have been several months before June 12th, 2013, that she was essentially, the defendant was abusive to the victim and the victim was afraid of the defendant. It says that, just one second, forgive me for not knowing the answer to this, but is this 1109 evidence? And we will stop there. That will conclude our Q&A practice.